All right. I'm going to get some work done today. We got Honey the Bear dog vision. This was the best angle that we could compromise on. She's doing pretty well, I think, with that. She was not a big fan of being online there and coming to the studio, etc. What's Saturday? She's been, I think, 5 days as a city dog, and she is tired of it now. We can say that for sure. But we'll see what happens. Okay. So here's what we're going to do. We've got some serious, when it rains and pours, we got some serious Pechacek, Carr updates here for you all. At one time, I had several DOC cases going simultaneously, but I think this is sort of the last of the pre-COVID ones that's filtering through there. That's got Pechacek as one of the actors there as well. Let's just get a little bit more Honey vision as we've got her there. Who knows how long she's going to put up with this garbage. So she's an Anatolian Pyrenees. That means that in this case, her mom is a big poofy Pyrenees dog, and her father is an enormous, terrifying Anatolian Shepherd. And the whole concept was that although Pyrenees are amazing dogs, they needed to be toughened up for the livestock guardian business in America. This may be fine for France, but this is America. So I think that was sort of the concept behind that, also known as Colorado Mountain Dogs. I happened to get her from a breeder who happened to be in Milwaukee County, which was shocking. And I think I paid $350 each for them. I asked for the smartest one you have and her best friend. And Hunbert qualifies as her best friend for sure. We may bring smokes in. We'll see how she feels about being in the city. Man, is this a different environment than Lala. I mean, this dog, besides being 140 pounds and has the ability to, she doesn't have to put up with anything. Let's put it like that. She's so gentle. She's so nice. She really has caused very little trouble. It's extremely less destructive than Lala. And it's just a weird sort of combination. And in fact, my daughter really was able to walk her around the block no problem. Nobody can walk Lala, let alone Patches. So that's our Honey story for today. Good, she's done her honey duty. Let's say she has been amazing at just sitting there, which is, I guess, mostly what she does is sit there, watch goat. And yeah. Anyways, she hasn't hung out she does this probably once or twice a year maybe, but not like this. And she's really acclimated. It's kind of astonishing. So I'm sure it'll be hard to let her go, but hey, these things happen. So on to this case. We're going to sort of slow roll this one out, I guess is the best way to put it. I have full permission here now to discuss everything, but I'm still going to leave out a lot, and we'll sort of go from there. It does involve some, I guess the SA is the word that we use around here, and besides anything else. And the complainant told me that if she gets bullied, it's their problem, not hers. And let's say that I think she's at the beginning of that journey, but yeah, that would be, it's just a shame that anybody would have to feel that just to tell their story about what happened, they would have to be afraid to be bullied. So I hope nobody's here could possibly be responsible for anything like that. But hey, it's an internet. So, she's an employee at the Department of Corrections. and I do believe this is in sort of the Novak ambit. I think this is all pre-COVID, all the events surrounding this. So there is a ice fishing trip that they go on. During the ice fishing trip, one of her worker guards SAs her by grabbing her, let's say, her chest. This happens at least in the view of several coworkers and as a whole thing. Charges do stem out from that. Going back from before that, there are several complaints made by this young lady that she is being bullied by a captain, a white shirt. So that sort of the ranks of the DOC, officer, sergeant, lieutenant, captain. Then it starts going up to security director. Then you're in the management area. The HR people are sort of above them in certain respects. Security director, deputy warden, and then going up to Doug Percy, for example. So that's sort of the chain of command there. And remember, nominally speaking, I mean by law, the warden is the head of that institution. They're the appointing authority. So they've got the power to hire and fire. But in fact, we know that decision is rarely, if ever, made by them. In fact, it's made by the secretary in consultation with HR, and then that decision is pushed down to the warden, who is then expected to sign off on the decision that's been made for them. Which, again, isn't necessarily a bad management structure in and of itself. It's just that it's being, by law and by word, it's something else is going on. So that's a problem. Okay. Oh, I do have a case, by the way, that is attacking that issue head on with Carr directly. It's the same sort of thing. Because the warden fell out of favor, I think the other person had to get, they couldn't use the warden to discipline people for whatever reason. And so the disciplining is coming not from the warden, but from even above. So they've got somebody else even signing that. And it's my, let's say, my contention that causes a problem for them, because that's not what the law says. So we'll see how that works out. So now backing up here, the white shirt captain is bullying this officer by essentially spreading rumors about her, particularly, and there's the bottom line issue, I think, is, why is this captain spreading rumors about and these are, all sexual related rumors about a extremely junior employee. And for whatever reason, I suppose that captain sees the extreme junior as a threat. And I will say this, departments of correction, prison institutions, particularly the guards, there is they are frequently having relationships with each other. I think that's statistically will bear itself out and is totally fair to say. And one of the reasons for that is that it's an extremely stressful environment. And I think also it's because, and many of the people are in a continuous cycle of divorce. So they're about to be divorced even before they're getting married. It's just really a matter of time. And then that all goes back to the working conditions and the environment and the so forth. The issue here is, if you'll just bear with me, the issue here really is not just, I would say, the keeping of people in behind bars, because that is difficult, I think, to do. The issue also is the hours, the shifts, right? It's a 24-hour institution. People, especially working second shift, third shift, whatever they have there, there's just all of these factors are going to come in on everybody. Everybody's working for their 20 and their high three, meaning their pension, and to get the heck out of there as soon as that they can. And there's also an extreme culture of covering your butt and keeping your eyes down. So I think a lot of people can, sympathize with that. But when you're out, you're out. And also, there is a lot of narcotics. There just is. It has nothing. Everything that I'm saying has nothing to do with this case in particular. This has to do with my knowledge and experience, or any case in particular, has to do with my knowledge and experience of going into prisons with dealing with employees who are having problems with the prison system. So it is astonishing to me. There's also, I mean, Green Bay prison right now is on a lockdown, and it's a pretty horrendous situation, and it's got to be awful for both of the inmates and for the guards as well. I mean, having it seems like it might be easier, but my guess it's twice as much work. They've got to bring them all the food. They've got to do everything, and some of these prisons are not in the best condition, and it's pretty bad. So, my client complains about bullying. They sort of investigate it, but nothing happens. In fact, it gets worse, is my understanding. They go on this trip, and it's my contention that the SA and the other harassment that comes up is totally related to the fact that a manager is encouraging and in both direct, not just spreading rumors herself, but directly bullying the complainant. That's what is alleged in this complaint here. We got to be really clear that although I'm talking about this stuff nebulously, we're still at the complaint phase. We have yet to have a hearing, so we can't say that this has either been proven or that so-and-so has said this, that there's been testimony to this fact. So, and we're not really at the interesting part. This is all pre-COVID. All this is fine. Okay. So we have, then they go after this SA event happens. An hour later, they're still at this thing. They go into the restaurant area of this ice fishing thing, and one of her coworkers goes up to her and asks to see her breasts in front of at least one supervisor, but probably like 3 or 4. Both of these incidents are investigated, but one of them, the actual touching, is at least criminally charged, and which results in a no contest plea. Okay. Those then are supposedly, but not really simultaneously investigated by the Department of Corrections. I have no information on what, if anything, happened to the person who asked to see my client's breasts, meaning internally. So again, this happened at a work function, although it was, let's say, not mandatory. It was being held by the work. Everybody there was work related. There were supervisors there. I think this is no question that, for example, workers' compensation would apply. I don't think there's a great issue here in this case about whether or not this was an employment situation. Then what happens is they give that guy one, and this is when I say they, let's be clear. Secretary Carr gives the person who sexually assaulted my client 1 day of suspension. So for everybody out there who's listen to this testimony at the department from the Department of Corrections and what happened to Sue Novak, Brian Geske, the like, and everybody else who knows any other punishment that's ever happened to any other Department of Correction employee. Let's just all talk about all the wardens and all the investigations into escapes and everything else that we know about. You just tell me if you think a 1 day is a proportional penalty for sexually assaulting a coworker in front of other coworkers. The context especially does matter because besides just objectifying a person and treating them like a piece of meat, it also is extremely humiliating when that's done in front of their coworkers, the people that you need to go into. You don't have an option not to go there again. This happens at church. In theory, I guess you could find another church. If it happens, the grocery store, you can go to another there's options there. The concept here is your only option is to lose your career. Okay, maybe that faith example isn't the best one. I don't know, but I might. For example, a Catholic church, I think we can say that it's might not. You're losing out on your community. Yes, it's a hardship, but that's the same thing that's happening at work. It's just that you're going and starting from ground. Maybe they're exactly parallel. I don't know. You tell me. But again, it's state-sponsored, and this is the government that's creating these conditions, and a government that at the time was run by a governor who was saying equity, equity, equity. That's my understanding, Tony Evers. So, because again, Secretary Carr is the gentleman who puts in this 1 day suspension. And you also tell me if you think that fits in with terminating the emotional woman and the 1 day for the sexually assaulting man, if you think those things are on the same continuum or not. Some might. Okay, so after this 1 day suspension, this assaulter comes up. I guess can you say that if he doesn't contest assault conviction, whatever it was for, meaning no contest, I think that's, we can say that. But if I'm wrong on that charge, I will accept that. But we can say that I think he does not dispute that. So, no, I want to be clear. We can say that he accepts the criminal liability for those actions. He may dispute the underlying facts. I don't know how, but that's up to him to show if he and when he ever gets sued. I think that's more accurate. Thanks for bearing with me on that one. Again, you have to strive for accuracy in all things, especially when you're talking about things that are so troubling as this. So the Department of Corrections basically puts the assaulter and the victim in the same working environment. In one way or the other, they're immediately, I think, put on the same shift even. And she complains about that, just seeing that's possible. And ultimately what they do is they send her to Madison. There's two offices, and now I understand. She's in the central headquarters in the front office, talking to Secretary Carr as he's coming into work every morning. Yeah. So then what happened? And I don't discuss this. I don't learn of this fact, and I don't think that she quite remembered this fact. And the reason that I bring this up is that with this kind of trauma, and I think we really, and I may have misunderscored how not only just humiliating the event it was to begin with, but then to be forced to go into those circumstances again, And it's my understanding that people were, saying things to her like, how dare you show your face around here again? I can't believe you did that. Sort of as if she was responsible for charges being pressed against a uh, coworker. I mean, she complained about it, but there was a crime that happened. So I don't think there's any dispute about that. We pled no contest. So, but so she's getting, victim blamed, and then having to, see him, even if it's crossing somebody in the hallway. And the way that this works is this, okay? As an employee, even one who's seriously sexually assaulted, you do not have the right to say you have to fire the guy who assaulted me. Okay? That's, because you're not the boss. And to put it another way, the courts aren't going to make them fire so and so. Okay? It's just never going to happen. That's not the law here in Wisconsin. I don't know how it is where you are, but that's what I'm talking about. So, what situation does that leave you is, or leave them is, if they don't do it and the thing happens again, or in this case, the trauma is exacerbated, triggered, you having, you're essentially being disabled for whatever reason, then you have this issue of the employer could be potentially liable for that failure to adequately deal with the situation. Now that assumes a lot of things, that you were sexually assaulted, that you can prove it, that you can prove the employer knew, that the actions that they took weren't uh, commensurate with what was going on. Now, I had a case, for example, one time where somebody had very, very tangential contact, minimal contact with the person who was supervising them. No, sorry, assaulting them. And I don't want to use whatever. Bad contact person reported to HR. They took positive steps to keep them all from being around. But I think the guy was bringing, one of his duties was to bring, because of where he was to bring trash down. And that involved him coming down to where he was. Well, she happened to have her own previous issues. So which brings up another employment issue, which is employers employ who they employ. Okay, what that means is two people can be victimized in the same way. Okay, so a boss puts their hand on the posterior of two guys. Okay, and one of them had been sexually assaulted as a child, and the other had not, and that would cause problems for that person, because that employer, without even having any knowledge of that, because one person could be shake it off, and the other person could need serious emotional damages, go in trauma and disability and all the rest. So you see how, and it's the same thing here. It's the same kind of concept for an assault of any kind, right? If I touch somebody against their will, and somebody's got some rare, bird bones or something like that, and I cause them significant damage, whatever the damage is on me, because I caused the problem. And if they're a tough guy and they just, laugh, I accept those consequences too. But either thing can be an assault. You see what I'm saying? So either thing can be an illegal employment action. The question is, what's the damages? So that really is the question there of what's the employer's responsibility to mitigate the continued issue, and the fact that the continued issue can not only be repeated acts of harassment, It can also be, and here again, there's two things going on. There's the harassment from the coworkers about, how dare you, the victim blaming. Then there's also the fact that she's got basically a disability that's being triggered by the fact that this, you know, person who assaulted her in a public employment context, is being put in to work with her. So the you see how those two sort of distinct categories, all flowing from the same event, their failure to ultimately separate this guy from her. Okay, and if they wanted, you also see, I think, that the solution is not to why doesn't the let's step back here. Being a correctional officer is not, may or may not be that great of a job, okay? But it is a career, and you can see how there's a ladder where you can work up all the way to warden. I mean, we do have plenty of examples of that. Okay. So, do you think that your career as an officer is going to be improved by you being sent to Madison to open the door? Now, this person was on light duty at that time, so we got to keep that in mind. But there's no doubt that there was light duty available at that prison at that time. So she complains, and what does the Department of Corrections, Kevin Carr, do? They move her to Madison. Okay. Well, here's what happens in all of that. We get, years later, we get dragged down to Madison. If you recall, I complained about being called out there by Eric Mullenbach at 8 o'clock in the morning. Well, it was the exact same building that she had been answering the door in. And what does that do when she gets that address? As far as I understand, it triggers a lot of memories, which is, I think we can accept here at this point, something that happens to people in this situation, meaning certain memories come and go. So, hey. I think we can all accept, too, that being in the same, the location, all of those things, I think can trigger some of those memories. So it turns out that she was answering the door for, it's a big fancy state building. There's a person, you walk in there, they say, "How can I help you?" Yeah, well, the big fancy guys go up to the second floor, past this person. That's part of what she gives you a badge, you sign in, all that kind of stuff. Okay. So every morning, Pechacek and Carr would go past her. Well, she talked directly to Carr several times. Then we find out she also talked directly to Pechacek several times. Then we found out that within several days of her being there, she has a conversation with the head of HR, which at that time would have been Chrissy Preston, head of internal affairs. Because if you can recall, the internal affairs was something that, for the Novak decision, that there was something that Carr basically created to take power of investigations out of the hand of wardens. So, I mean, that's a finding of fact by the state of Wisconsin. So, okay. So, my client talks to the head of internal affairs, who tells her that Carr and Pechacek are aware of the circumstances, because of course we know they are, because there was an investigation into both of the incidents and the bullying by internal affairs. And internal affairs reports to Pechacek and Carr, who then, between the two of them, they call it the cabinet, make the decision. So that's how the decision of one day goes. Okay. So as far as I understand, the head of internal affairs tells my client that what happened was not right, and she hopes that she gets everything that she deserves, which is, we get this fairly often. I'm not going to help you, but you should sue. Which is, nice, but hey. So she also tells my client directly that both Carr and Pechacek know about her transfer there and why she's here. Because, of course, the warden can't transfer her to Madison. And as we know, if the warden's not doing it, then it's made in consultation between if Mac is doing something like that, we've got her own testimony that she just knew that it all had to be in consultation with Carr, meaning she had to ask his permission. That's what I get from that. I don't know about you. So, okay. So, this all comes out in the deposition. And we've got it here. So, hey, by the way, I had been telling Pechacek's office about this case and the fact that I wanted to depose her for the past 3 months, I think, or more, and she's never responded one time. I've talked to their attorney, never responded. Not one. I've called them, left messages saying, hey, we may need to depose you because of this issue here. She is, even before we had this direct information, we knew she was the supervisor of internal affairs and would have supervised these investigations. So we said, hey, we want to set up a time to do this because, we understand that you're busy and like that. So she never responds ever, 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 ever. So, okay. So, it's also slightly different because Kevin Carr is the Secretary of the Department of Corrections, and he has to show up, meaning he is the respondent, in other words. Whereas Amy Pechacek, even though she is a secretary that is incidental, really she's a ex-employee of the Department of Corrections who now is a third-party witness. That's why that status is different. And then you would have, if you even were slightly contemplating deposing her, you would contact her and say, hey, recognize you're busy. Is there a time we can talk about making this happen? Is there a time that works for you? I've got these dates free. Let me know. Which is what I did. Because, courtesy. So we go and talk to... And I appreciate it. I see I'm at the half-hour mark, but I hope that everybody's sticking with me because this is where we're going to need the help. So we then send a notice to right after that deposition where all of this comes out, saying we want to depose Head of Internal Affairs, Secretary Carr, and Amy Pechacek. At which case, all hell breaks loose, and I get calls from the Department of Corrections. No, I get no calls from them, but I get a huge amount of emails from them. I get a notice of appearance from the Department of Justice, Wisconsin Department of Justice, saying that they represent Amy Pechacek. And then both of them file protective orders against me, the deposing of Carr and the deposition of Pechacek. Okay? Here's what a protective order is. I, as an attorney with a filed case that's not subject to a motion to dismiss, have the right to depose people in discovery. Okay? So that means I can send them with just my signature a subpoena. And believe me, if I, screw around with this, there can be big consequences for me. But with just a subpoena, I can go and compel somebody to show up at my office on a certain date and time of my choosing and force them to tell the truth under oath. That's a pretty big deal. So there are some limitations on that, and secretaries, high government officials enjoy that. Right. Now, up until now, I have deposed Kevin Carr at least once. I've deposed Head of Internal Affairs variously, I think a couple of times. I've gotten Kelly Brown a couple of times. I mean, there's really not too many people higher than I think it's more fair to say that I was negotiated and had successfully negotiated to depose Kevin Carr, but the case settled. I think that may be the case. You've seen Kevin Carr on, you've seen everybody on Novak, and there never was an issue with any of those about them being highly placed government officials. Okay, so this is not the first time I've ever seen this, but I just want to be clear in this sort of whole transaction here. This is the first time that that's come up. So, okay. So both of these, they file it like late on Friday night, supposedly, and send me an email. Then, and we're going to go over that. And it's basically like this. There is a federal case out there, and there's a state case that says that highly placed government, it says, we conclude, this is the state case, Beloit Concrete Stone, state versus Beloit Concrete Stone. We conclude that a highly placed state official who seeks a protective order should not be compelled to testify. So that's the thing, that they've got highly placed government official can just throw out a protective order, and then it places the burden on the person seeking the thing. So in essence, that you have to make a showing to then get past it. Okay. Cannot be compelled to testify on deposition in their official capacity unless, and this is clear, I think there's a distinction between a hearing and a deposition. I think that's fair. And one of the reasons is because at a hearing, the judge is there to say whether this is relevant or not and to make instantaneous rulings, whereas at a deposition, it's not the case. Okay. If that deposition is necessary to prevent prejudice or injustice. And determining whether to grant an official's motion for a protective order, the trial court, meaning the ALJ here, should consider, among other things, such factors as the effect on government's business, if the official must attend a deposition, right? So that's effectively curtailed by the fact me going ahead months ago and saying, hey, when can we do this? And the likelihood that the alternative procedure provided by the statutes will provide the party seeking discovery with the information sought. So that's basically like, can she send a deputy? Okay. So I think that that's one of the things that they're saying here was he can go ask Kelly Brown, the head of HR at the time, which Kelly Brown may be able to say what they said, but that's still going to provide. That leaves me with some troubles because if, for example, let's look at it like this. I need to authenticate a document that says a memo from Carr to Kelly Brown saying, you know, this person's a jerk and they're fired. Okay. If I was going to go after Kevin Carr and say only Kevin Carr can do that, I think that that's absolutely right, that I should go to Kelly Brown first and say, hey, Kelly, are you available to authenticate this one? And then go up the chain of command. Makes perfect sense. And that's the whole concept, I think, of this rule here is that the higher you are up on the totem pole of highly placed government, the more stuff that you have to do through the day. And in theory, you know, the president, it's not appropriate to have a court official without a showing, compel the president of the United States to stop what he's doing at a state dinner to go testify when somebody else could be doing that. Okay, I think that's the genesis of that logic here. Okay. So clear showing. Now we got to say that the deposition is necessary. So that's the first thing you have to keep in mind out of there. So you have to show that you're not just doing this to get information, that there's information that you have to get out of this, right? So how was this decision made to only give this person 1 day? I don't think there's anybody else in the world but Kevin Carr who can answer that question. Why did you make this decision, sir? Kelly Brown is not going to be able to tell us why Mr. Carr made that decision. Now, that may not be as clear with Pechacek, but here is the key fact to remember that Pechacek is the supervisor of internal affairs, and that internal affairs reports to Pechacek on the status of the investigations. So she is a the question then becomes, okay, well, what did you, Pechacek, do with that information? So, and this is quite astonishing. We have affidavits filed for both Pechacek and Carr stating virtually identical information. One of those things is that Carr has no knowledge. Here's I'm going to quote from the Attorney General of Wisconsin. As her affidavit reflects, Secretary Pechacek had no involvement in the underlying dispute, no knowledge of the claim it asserts, no recognition of the name of the complainant or any of the key witnesses, and no involvement in the underlying investigation related to the complainant's case. Okay? So that's where we need help right now. And I'm going to say that again, because this is the question. Does we have evidence to put this another way? Okay? As her affidavit reflects, Secretary Pechacek had no involvement in the underlying dispute, no knowledge of the claim that it asserts. Okay, and I think we just went over the claim. No recognition of the name of the complainant or any of the key witnesses. So I assume that would mean Toutant or let's say the other gentleman and the investigators. God, I can't. The name that I was trying to think of is he was like the last witness in Novak. He's driving me crazy. I'm sorry. So he's the head of internal affairs. He's one of the guys. There's two investigators. He's not the head of internal affairs. There's two Sonnenberg, Joseph Sonnenberg. That's the name I was thinking of. So she's also supervising the investigators. She's supervising the head of internal affairs, and so I mean that's the involvement in any underlying investigation related to the complainant's case. I'm sorry, I messed that up. We're gonna start over one more time. Okay, no involvement in underlying dispute. Okay, I assume that means that she was not like a witness directly to the bad acts. I think that's what that means. I don't dispute that. No knowledge of the claim it asserts. That based on what the head of internal affairs told my client, that doesn't seem to be accurate. I don't know if she recognizes the name of the complainant or any of the key witnesses. I don't know that that's the test. Let's go up there and look. And no involvement in any underlying investigation related to the complainant's case. I don't know how that's supportable. The term no involvement. So that's really what I think of the ones that I would focus on. It would be no involvement. She may not have any recognition, but that may just be a red herring. Let's just go up there. The standard is set forth. They say the standard is that we must demonstrate that the particular official's testimony will likely lead to the discovery of admissible evidence is essential to that party's case. That's essentially, by the way, I won't say essentially, that mirrors the standard for getting an attorney to testify in a case, or really to disqualify that attorney as a necessary witness. It has to be essential and admissible. I think that's fair to say. That's really a simple concept. Admissible, it has to be under the laws of evidence, has to be admitted. It could be admissible. Testimony by a secretary is going to be admissible. I mean, that's not that crazy. I mean, we can't be asking her about client protected client things. We can't. I mean, so that's a stage beyond relevant. Okay, it does need to be admissible, which is that. There's no question about that. Relevant is really low. Admissible is higher. Okay, there's all these. Relevant just means related to the case, and the standard usually in discovery is likely to be related. But this is even a higher standard. That means will likely lead. So demonstrate that likely lead to the discovery of admissible evidence. Okay, that's pretty much the same standard. But it's likely lead to admissible evidence, not likely lead to relevant evidence. That's the distinction there. I'm okay with that. Okay, the key thing that we're going to be focusing on here is essential to the party's case. Okay, this is their statement of the law, and we're just going to work with that here. I think I've got some minor quibble with that, but as far as we're concerned, the question I'm asking you here now is, do you believe that Secretary Carr or Secretary Pechacek would have information essential to proving why the Department of Corrections only disciplined the one-day discipline, and instead of, after she complained about him being in proximity with her, that they moved her instead of moving him? Okay, those are the I would say the two crucial questions here in terms of the underlying dispute or the claims that we're asserting here. Okay, so do you believe that she doesn't have any involvement in the underlying dispute? Because I think it's more, if you focus on what happened at the fishing, that's one thing. Okay, that's not really what the issue is. The issue was, how did management deal with that? Okay, so if you think that the Deputy Secretary of the Department of Corrections had no knowledge of how the Department of Corrections disciplined the SA perpetrator, I'd be interested to hear why you think that. Okay, if you think that they have no knowledge of the claim that we're talking about, I don't know necessarily how that's different, but okay, no recognition. Again, if you think that she can plausibly say that she doesn't recognize either the complainant's name or the other two, I'm just guessing based on what happened and the fact that there was a criminal penalty that and now the testimony of the client saying the head of internal affairs said they knew all about it. I'm guessing that they knew all about it. And no involvement in the underlying investigation. So now I think we've gone through it 3 times. I think you've got your homework all here, and boy, do I appreciate you sticking with us. Holy blowy. I don't even know. I'm gonna thank you all for sticking with us. We don't need an outro. We're done. Thank you all. Stick with us. We'll keep you informed.